the perspective that we got from Mr. Ben and also Mr. Dennis, I would like to have some discussions with respect to your presentation and also to give the inputs. And I think if everyone, all of the attendees and participants wants to also give questions, you can put your questions in the question and answers chat. Or if you also would prefer to ask your questions directly in the forum, please raise your hand. We'll be happy to deliver and give the opportunities for you to speak directly and ask your questions directly to our speakers. So I think we'll discuss a bit more during this moderated session. And we have 30 minutes of the discussion. And I will divide this conversation into several stages, where the first we try to discuss first on the framing itself on when money gets stuck, and then we'll discuss later on about how sanction, payment control, and contractual mechanism will be affected and to be mitigated from the very beginning. We will also discuss later on about the currency, government regulations, and contract performance in the context where it could cause the money gets stuck. And then later on, we also could discuss about the dispute tribunals, and maybe we can discuss more about the tribunals, and hopefully there will be a message for looking ahead and the takeaways for everyone's attending this event. So first, on the first theme about the big pictures on when the money gets stuck itself. So I will ask these questions to both of the speakers, and I want to dig on your experience on what will be the most common ways that when we talk about the money actually gets stuck in a cross-border deal, as current today's situation where that possibilities may occur. Is it sanction, capital controls, counterparty insolvency, currency, or the banking channel itself? So probably if both of you could give comments on that one.
Dinesh, please go first.
Yes, Mr. Ben, please go ahead. Please go ahead. Great honor to hear you.
Thank you. Honestly, Kirana, my experience as both barrister and particularly as arbitrator is that we are often not told the real reason why the money gets stuck. We're often presented with fancy legal justifications for commercial decisions that no one wants their lawyers or their tribunal to know about. But sanctions, capital controls, banking issues, currency restrictions, I'm sure they all have a role to play. But my suspicion is that the primary cause of money getting stuck is much more mundane. It is probably counterparty liquidity issues or insolvency issues, or simply the desire not to perform one contract and to look at a better business opportunity that has arisen subsequently.
Thank you. So if, for example, when a respondent says, we could not pay because the money was stuck, so how much weight does that carry? And what do you need to see before it becomes an event, rather than just basically an excuse for not performing their obligation in the contract? Ben and Mr. Dinesh, you probably also could comment on that one too as well.
All right. Now, as far as tribunal is concerned, tribunal can pass an order, but then the order has to be executed, and that order will land up in the court. And when the order lands in the court, it will again get adjudicated. They will again fight it out there. So that the point is, when the tribunal looks at it, tribunal will not get convinced by a sweeping statement that I have no money or my money got stuck, so I can't pay. No. Tribunal will go into the deeper details. How much money? What money? How much money did you have? Where was it parked? What problems did you face? What is the window of opportunity did you have? What is the scope? Why can't you pay? You had this option, you had that option. So all these things will come into picture before the tribunal passes any order. And it is not sufficient to just say and get away that my money got stuck, so I can't pay. Thank you.
So, Kirana, you are mute at the moment.
Kirana, you are still muted. I hope somebody.
Sorry.
Yes. Yes.
Okay. Thank you, Mr. Dines. So, Ben, do you have anything you want to add?
No, I'll save my powder for subsequent points that you're going to make.
Yes. Okay.
Or you're going to ask us.
Well, I mean that I like that you're basically focusing on the sanctions, so we can dig more on that one. I mean that you offer several case studies in English and the Singapore court. So yeah, for us as the audience, where we got all of the case precedents lining up with respect to the sanctions and how they impact the performance of parties in contract. So from your perspective, what is the, if it is like the single most useful lessons those decisions give us about how a court or tribunal will respond when sanctions actually collide with a contractual obligation, Ben?
I think there are 2 points. I think in a series of decisions, including the celestial aviation case I referred to, the English courts at least have said that if there is any balancing to be done between sanctions regimes and contract terms, the sanctions regimes will take precedence. Without going into the reasons for that, that seems to me to be quite a common sense and unimpeachable view. The second point is when it comes to determining contractual liability, which is ultimately what a tribunal is going to do. The first port of call is always going to be what the contract says, either expressly or impliedly, because that will show, at least in theory, what the parties themselves considered to be the appropriate allocation of risk in respect of the event that arises, whether it be sanctions, whether it be currency fluctuations, whether it be some other external event. So a tribunal and as a counsel representing a party, the key is to work out as best as one can what the contract means and what the contract says about the particular event that arises.
Yeah, thank you, Ben. But it's usually that sanction regime, it's changed quickly and it happens in the middle of contract performance. So when there is like the ongoing contract and there is sanctions in the middle of the performance, how usually the tribunals actually treat it?
The tribunal has to treat, this is called a supervening legal impossibility or a supervening legal event, if there's a sort of a change of legal regime. The situation is still the same. The tribunal will still have to determine, the court of tribunal will still have to determine which of the parties assumed risk for this particular event happening. It may well be that the parties haven't turned their mind to it, but under the contract, one or other of them will be determined to have assumed the risk for this particular sort of risk of non-performance. So the essence, at least in a common law perspective, the essence will still be found, the essence of the decision will still be found in the 4 walls of the contract.
Right. Well, so what will be the important one is for the practical approach then, when you are advising, I know that you said that you're not advising, but if you, and also Mr. Dines, you're saying that probably contract will not be able to carry all of the risk, but from contractual perspective, in this situation, what would you be advising on new cross-border contract in this period of time? What is a single sanction-related provisions you would like to put in the contract? And if you are advising clients, you definitely will remind them for not forget to put that particular clause in the contract.
Thanks, Kirana. The point is that I'll take you on the ground now. See that there is a natural bottleneck. So tens and hundreds and thousands of ships are there on one side, and on the other side, they are unable to cross. How many jurisdictions, how many corporate entities, how many businesses are affected? And one, previously, somebody else was controlling. After some time, somebody else was controlling. So that natural barrier was being controlled by A jurisdiction. And after some time, that natural barrier was imposed by B jurisdiction. But then C2Z are suffering. So the point here is that in our contracts, we cannot afford to have streamlined or dictated to each and every contingency. We have to have a very general, specific, and leave it to the tribunal. I'll give you an example that because the world, now let me, before I give you an example, the world has dealt with the COVID-19. We have discussed enough force majeure and all those hardships and all those things were webinar after webinar, hundreds and thousands, and we passed whole COVID discussing all that. Now there's a new situation. Now the situation is that the parties who are affected are not involved, and the party who are involved have got no contract with the parties who are suffering. So that who is responsible? Now one party will say there was a window of opportunity when 4 to 6 to 7 ships crossed the national barrier. Why didn't you cross? He will say, come on, have a heart. I was in the queue, and after 6 or 7 ships crossed, there was again there was a ban. I was held up. And I was not held up because of my choice, because it was forced upon me. And imagine the crew and the seafarers are there on board for days, weeks, and now months. And the ships are also, they cannot, because you forget about the perishable items. So we are going into non-perishable items at least. So now what will happen to those? And who will be responsible? Who will be held responsible? But then it is yet to be tested, and the disputes are to come to table, and some jurisdictions have already announced force majeure, and whether that will be held up or that will not be granted so easily, and then we'll have to see, and the tribunal, based on the material put across before it by the parties, both the learned councils, we'll have to see and then judge from case to case. There cannot be a broad brush. There cannot be a sweeping solution like this. We are going to a very, very challenging time, and all of us have to gear up for that. And every case will be a different case. It must be getting queued up right now. Thank you so much.
Yeah. Thank you, Mr. Rina. So it's almost the same as well here in civil law countries. Yeah, we try as much as possible to put everything and try to make a perfect contract, to put as much details. But in the end, sometimes the best is to have like the more general one. And then later on is how to argue and try to get the evidence to support the arguments, because condition change and how tribunal look at the situations will really depends on what the actual situation and how the efforts of the parties to prove that. So even like the COVID situation as well, where there's a declarations of COVID, does not entirely mean directly that the force majeure relief can directly invoke in contract performance. How about you, Ben? Do you have different perspective on that one, or you look, for example, if this relates to sanction, for example, so it's actually not common in the civil law contract to have a particular clause related to sanction. Yeah. So how is in the common law contract model, and do you oftenly look at see at the certain sanction clause being incorporated into contracts?
Yes, there is often in certain forms of standard contract clauses that deal with sanctions. That's not uncommon, but there's always going to be a question of how general to make the clause or how specific. And in an ideal world, every clause would be bespoke, and it would address who the counterparty is, what the trade is, where the trade is taking place, and so on. But realistically, contracting parties don't have the time or the foresight to conclude every term as a bespoke term. Just occurs to me, at least in recent times, that an interesting consideration might be to think about denominating your contract other than in US dollars, particularly if the contract has no other connection to the United States. Denominating it in euros or Singapore dollars, or I forget the name, but I know the BRICS countries are putting together some sort of proposal for another currency that is distinct from the US dollar. That might be a way to at least start thinking about how to avoid some sorts of sanction issues. So I just throw that in there as a possible point to think about.
Interesting. That's because of the US regime sanction, yeah, for avoiding US dollar.
The fact that every US dollar transaction has to pass through a US bank that will be subject to US sanctions.
Okay. All right. Interesting. Okay. So move from the sanctions. So we probably also want to discuss a bit about the context of the current situations where in certain Asian countries there's currency devaluations, government regulation, and how that affect the contract performance. Like, for example, currently in Indonesia context where the currency situation, rupiah situation, for example, it's really under sustained pressures, and Indonesia business will recall how sharply this one can happen. So we have been in these situations several times in past, like for example in the crisis of the 1997 and 1998, which Mr. Dinesh kindly explained previously, and also the disruptions on the COVID situation, and now the current situations with the situations in the Middle East. So I want to draw out with our speakers here how the harder legal questions that sit on the headline as a matter of contract. What does currency devaluations or a government measures actually change what a party is obliged to do based on the contract? So question to you, Ben, making comments just from the common law principle. Basically, when a contract requires payment or performance and the paying party's home currency collapse, does that depreciation, even though it's very severe, will change the obligation at all in the contract? Or where does English law draw the line between obligation that has become more expensive and one the law will actually excuse?
I think the general position, of course, it's always going to depend on circumstances, but the general position is, as a matter of English common law at least, the currency depreciation in a party's home currency will not be very significant. I suspect a court or tribunal will take the view that having contracted in, for example, US dollars or euros or some other independent currency, the parties have anticipated that payment will be made in that currency regardless of currency fluctuations. So I would, even though the ultimate performance will become much harder if there is a local currency devaluation, I suspect an English court or tribunal will not be overly influenced by that.
Right. Even though much more expensive as well.
Well, it's only expensive in one sense. It's no more it's no more expensive in the currency in which the parties agreed to contract.
Right.
It just becomes much harder for one party to fulfill that obligation. But the obligation itself to pay $10 to pay $100 or whatever still remains the same. Sure. So in a very real sense, although it's not necessarily a practical sense, the burden of performance hasn't changed at all. All
right. So how about if it is caused not entirely by change of the currency, but because of the government regulations where, for example, government suspends, terminates, or interferes with the contract. For example, suddenly put capital control, export ban, or directly do the terminations of the contract, for example. So how does a common law tribunal usually treat that way?
Are you asking me again, or perhaps
Dinesh? Asking you, but if Mr. Dinesh also want to give comment as well, you're also
let me chip in here. I do agree with Ben, has very well explained that. But let me sensitize the environment that there are individuals, there are institutions, there are forces working day and night 24/7. And you will find that when you slept, your currency you were comfortable. And when you woke up in the morning, whoop, it has gone down, dropped, eroded. So now what happens? You have to be very careful. You have to have dedicated, devoted teams working 24/7. Any moment, any minute, on any sector or any institution or any business, something will come which will affect, which might affect, or which is going to affect, or which will get affected. Now, to take countermeasures immediately, the government, the central bank, the corporate bodies, they have to immediately get onto their toes without wasting any time and in damage control on an emergency basis. This is how you will survive in future. Now, as far as tribunal is concerned, it has got a very limited role because it can only weigh the pros and cons, the justifications, the arguments which are put across, and the sense the arguments make, and who prevails. That is all from case-to-case basis. And then I would leave again with a food for thought that somewhere in between, the parties could be afforded an opportunity to mediate. So there could be a pause in the arbitration, and party could be told, just explore if you could talk to each other, settle whether you are prepared to accept in another currency, or you would barter, or there is some other solution which can be worked out between the parties. And give them time, let them come back. If they get stuck, then move on. But then I have seen corporate bodies are very, very mature, and they have a lot of commercial sense, and they will help you out in overcoming this problem. Thank you so much.
Thank you, Mr. Dinesh. So how about in a situation where the counterpart is a country or a state-owned enterprise entities with the sovereign immunity arguments? So how usually you see the matters involving state-owned enterprise or country on payment, on sovereign immunity arguments and enforcement involving state or state-owned enterprise. How you see that?
Again, as a matter of common law, particularly in England, a state-owned enterprise engaged in commercial activity, not sovereign activity, will generally be treated as if it were a normal commercial entity. So that's really the simple answer. There is much jurisprudence on the point that if a public body is in fact acting as a commercial body, it will be treated as such.
Noted. So when we're talking about the enforcement of the award, so in a situation where we already have an award in hand, but the assets or the bank sit in a jurisdictions with controls or a hostile court. So what is usually, based on your experience, parties will need to deal with that situation? Do you have also comments on that one, maybe?
Get local legal advice.
Okay, sure.
Seek another place for, see if there are assets in other jurisdiction to enforce.
Right.
The reality is many court decisions, many arbitral awards are difficult to enforce in certain jurisdictions.
Yes.
And that is why when a client comes to me, I'm sure to you, and seeks advice about a potential claim, one of the first questions you ask is not about the merits of the claim, it's about where do they think the assets are and do they think they can attach them, because otherwise everything else is a intellectual exercise only. So enforcement is always going to be an issue.
Right.
So Kirana, if I may add here.
Yes, Mr. Ines.
So the first option, of course, you have to activate the courts where the assets are parked. That is first. Whether whether these are hostile or not hostile, I'm not discussing. Because I take it for granted that they are neutral. All right. Start from that.
Okay.
Now, if you fail to persuade for any reason whatsoever, then the world economy is so integrated that you can't isolate forever. There will be an opportunity here and there. If you keep an eye and keep chasing, you will find some asset somewhere parked or transferred, and you can immediately lay your hands on. But you have to be on your toes, whether it is aircraft or it is bank account or it is ship or it is any other asset for that matter. It will come out from that jurisdiction which are difficult, which you find it difficult for enforcement. All right?
Yes.
So I'm not going more on that.
Yeah.
I have communicated well my point. Thank you so much.
Yes, that's true. It's very clear on that one, Ines. Okay, so we are about to the end of the time of this session. So before two of our speakers giving closing notes, I would like to offer to attendees here who want to have questions or raise questions. You can raise your hand. Yeah. So otherwise, then we will give the opportunities to Ben and Dinesh to give a closing statement. So let me ask each of you a single closing thought for 30 seconds. The one thing that you want this audience to remember when money gets stuck.
All right. As usual, Mr. Bain, please, all yours. After you.
My one piece of advice is going to sound extremely self-serving, and that is engage with your lawyers very early, and make sure your lawyers are experienced with international commercial disputes. The longer you leave that, the more difficulties there can be.
All right.
That's a good
thank
one.
you, Mr. Bain. Ms. Kirana, now my only advice is that having handled, when I was learning from FIDIC in construction disputes, and when I was learning in maritime, all these two different type of disputes, one thing is very universally applied. Make note of each and every event and incident. Log it. It will come for your rescue. If you don't prepare your records well, like Bain has said, you will fall short of evidence. You will not be able to convince. You will not be able to persuade. You will have your empty hands, and you will go empty hands. Create records, create evidence, not create. It's a wrong word to say, but document it. If something is happening, log it. Make a record of it and use it at an opportune time. Whatever is the dispute, whether dispute may arise, may not arise, even if for your record purposes, it will come very handy. And like Mr. Bain has said, I'll conclude. Please have your attorneys and barristers and advocates and lawyers perfectly chosen. Thank you so much.
Thank you, Dinesh. Yes, I think it's important. Like, people always forget once they sign contract, they think it's already done, and no one usually make a proper records of what things and what is the discussion thereafter. So it's important notes actually when we are about in the situations where dispute might happen anyway. So thank you to both of you, Mr. Ben Olburn and Mr. Dinesh, for two genuinely complementary perspective and for being so generous with your insight. We have traveled from what sanctions and control do to a deal, through the contractual mechanism parties rely on, into how the common law treats currency shocks and government intervention, and finally to the hard questions of enforcement. If there is one running through today, is it that the time to prepare for money getting stuck is before it does, for example, in the drafting of the contract itself, try to choose the forum and clear IRS allocations, and also what Mr. Dinesh said, make a proper record and documentations on what is going on during contract performance. And when there is actually event of the situations, the room for maneuvers has usually already narrow when we only prepare when the dispute arises. So many thanks to the BIAMC for organizing and hosting. Thank you to our speakers, and above all, to all of you who joined and sent such thoughtful discussion for this event. And I think a recording will be available through the BIMC channels. On behalf of all of us, thank you. Good afternoon, good evening, and good morning, wherever you are. So now station closed. Thank you.
Thank you. Thank you. Bye-bye.
Thank you so much. Thanks a million, everyone. Thanks, BIMC. Thanks, Kirana. Thanks, Rosa.